Welcome back to Law Stats channel. Today we're going to be discussing a case that we've all been waiting for, or at least many of my clients and many defense attorneys throughout the country. The Ninth Circuit finally made a ruling last week dealing with safety valve and mandatory minimums. And I will tell you, unlike other YouTube channels that deal with automotive stuff, or maybe a travel blog or a food network, it is hard for me to show you my work because after all, the biggest tool that I have in my tool belt is language. That's how I convince judges to interpret and follow the law. And for those people that enjoy talking about language, talking about statutory interpretations, you will really enjoy this case. And for others, I encourage you to talk to your attorneys about mandatory minimums, safety valve provision, and especially if you're one of those people who does have prior criminal history. This case makes a huge difference for those individuals facing mandatory minimums in federal court. So let's go ahead and discuss this case, and hopefully you will enjoy it. I'm really excited to share United States versus Lopez with you, a Ninth Circuit case that was decided just last week. One of the reasons I'm excited is because it comes from my district, the Southern District of California, so I know all of the players in this case. But the second and even bigger reason is that many of my clients will see a huge benefit from this case and how they're sentenced in federal court. Before I discuss the facts and talk about the case, let me first explain to you how the federal system works. When the person is charged with a crime, we first have to look at the statute. Many drug cases have mandatory minimum sentences, meaning that a person would be facing 5, 10, 15, and sometimes even 20 years in prison. And that sentence would be mandatory minimum, meaning that the federal judge cannot give that person less time in federal prison. Now, we always had what's called safety valve. Safety valve allowed some individuals who usually had very limited criminal history to get under the mandatory minimum. So the judge would be able to sentence that person under the mandatory minimum sentence. Now, before 2018, that meant that the person had to have only one criminal history point. Essentially, that person had to be in the first criminal history category. Now, in 2018, Congress passed the First Step Act. Because Congress thought that mandatory minimums were too harsh, they expanded it that other individuals with a little bit more criminal history could still be able to satisfy safety valve and get less time in federal prison. Now, I have many videos discussing mandatory minimums and how the criminal history works, but let me first give you a little overview. In the federal system, the courts punish recidivism, meaning that people with prior criminal history will be facing more time in prison after committing a crime if they have prior criminal history. How do we figure out prior criminal history? Well, if you've ever been sentenced to more than 1 year and 1 month, that'd be a 3-point criminal history case. If you've ever been sentenced to more than 60 days, that's a 2-pointer, and any other felonies or misdemeanors count as 1 point. It doesn't matter how much time you've actually sat in jail or prison, it is the sentence that we're focusing on. I also encourage you to watch my video discussing prior criminal history because it gives you more detail on what sort of cases we're looking at, what kind of priors count, what kind of priors don't count, also the amount of time we should be looking at, meaning the time looking back, whether we're looking at 10 or last 15 years of the person's life when we're looking at criminal history. And then if you're currently on probation, parole, or supervised release, there'd be an additional 2 criminal history points. Well, now let's move on to United States versus Lopez. United States versus Lopez deals with 18 U.S.C. 3553, commonly known as safety valve. Like I said, in 2018, Congress rewritten 3553 and expanded who can satisfy safety valve. And here's how the provision was written. A defendant would satisfy safety valve if he does not have more than 4 criminal history points, excluding any one-pointers. So anytime you've done less than 60 days, that's a one-pointer. We exclude those. But when we add the points together, you cannot have more than 4 total criminal history points. B, you cannot have a 3-point offense. So you couldn't have any cases, any priors, where you've done more than 1 year and 1 month. And finally, letter C, a prior 2-point violent offense. Those are the 60 days and more, but it has to be a violent offense. The reason why I wrote "and" in a different color, because that's where the fight began. The defense attorney said that you have to have all of these in order to be barred from safety valve, meaning that only when all of these 3 provisions are true, that's when you cannot get safety valve and cannot get less than mandatory minimum. The United States Attorney's Office took a position that whenever you have any one of these 3, that's when you're being barred. So if the person had a 3-point offense, he would be barred. And that's exactly what happened to Mr. Lopez. Mr. Lopez was charged in the Southern District of California for transporting methamphetamine across the border. He had 1 prior offense, which was vandalism, where he received a 3-point offense. It was a 3-point offense. Now, we know that he doesn't have more than 4 criminal history points. He doesn't have a 2-pointer. So the judge sentenced Mr. Lopez to 4 years, which was 1 year less than the 5-year mandatory minimum. The United States Attorney's Office timely appeals and says that that was a mistake. Because he does have 1 3-point offense, he does not satisfy safety valve provision. So then we get to the Ninth Circuit. How do we read this provision? Is this a conjunctive or a disjunctive provision? How do we read "and"? Does it mean when we have a list of items, A, B, and C, does that mean that all of them have to be true? Or when we say A, B, and C, it means that only one of them should be true. Essentially, here's the argument. The defense attorneys say "and" means "and." It means that all 3 have to be true, because "and" is not an "or." If it said A, B, or C, then it would be read how the prosecutors wanted it for it to be read. What does the court look at? The court looks at the plain and ordinary meaning, meaning looking at the dictionary. What does "and" mean? Well, if we look at the dictionary tells us that if there is a list of items and there's a word "and," that means it's conjunctive. It means that all of them have to be true. Then we'll look at the state's legislative drafting manual. So we'll look at the legislator, how they were supposed to be writing the statute. We're trying to interpret it. And again, the Senate's legislative drafting manual actually explains that "and" means "and." And then there's a list of other items that the court looked at. I'm not going to bore you too much. You can read the whole case. I will link it in the information below. Like I tell you often in my prior cases, I often don't write the whole site here on the board, but you can find more information below, under the video. And you can even click the link and read the whole opinion. The court looks at the canon of consistent usage, conjunctive negative proof, the rule to avoid absurdity, legislative history, and finally the rule of lenity, meaning that whenever we interpret the statute, we have to do it to the benefit of the defendant. So at the end of the day, the district court was correct in sentencing Mr. Lopez to 4 years, or at least the district court could have done that. As long as you don't have all of these 3 provisions. So, for example, if you have B and C, you would be barred from safety valve because you would have also more than 4 criminal history points, and then all of these would be true because we're reading it as and. But if you have, like Mr. Lopez, only 1 prior offense that's a 3-pointer, only 1 prior offense that's a 2-pointer, or let's say 2 misdemeanors where you've done 30 days in jail, meaning that you have a total of 2 criminal history points, well, then none of these apply. And that means that you are safety valve eligible. You are allowed to get less time than the mandatory minimum. Hopefully this video was somewhat instructive and hopefully useful to you. If you enjoyed it, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. Are you still watching this video? Are you trying to figure out what I was talking about for the last 10 minutes? So here's a quick overview. The word and means and. The word and does not mean or. So here's an example. Somebody comes up to you and says, would you like a strawberry ice cream or vanilla? You say both. And then you correct that person and you go, didn't you mean and? Because I want both of them. And if you'd like to purchase one of these awesome t-shirts, go to my website. You can get one there.